Right. Mr. Fasley.
Good morning, my lady.
So there's an issue that we might have to come to at some stage, which is whether or not this appeal is academic or not.
Yes, madam.
But that may well depend on whether or not we are satisfied that there is merit in your submission that you should be entitled to argue the points that you raise in the second skeleton argument, that is, post-permission being granted.
Yes.
But speaking for myself, and it may be something that we kind of take a view that you can hot tub in, having used that expression in another case this week, where we could ask you and Miss Patry to give us some assistance on this jurisdiction, which is quite alien in certain respects. Now, if, for the point of this question, we assume that there was, we thought, some arguable merit in your submissions which are raised in relation to grounds 2, 3 and 4, or any one of them, and we were satisfied that the Upper Tribunal had erred in its approach, which meant that it should reconsider its findings, does this jurisdiction permit us to remit to the Upper Tribunal, or is it... Oh, Miss Patry is nodding her head.
That's my understanding.
Yes, and you would agree with
yes.
that? I'm sorry, I wasn't being in any way exclusive there, Mr. Fazzi. It's just that Miss Patry just happened to be in my line of vision then.
Quite
So, so you would say it is therefore something that we could consider?
Yes.
That we don't have to say, as you would want us to say, no, it's quite clear that they were wrong on the facts and therefore there must be a removal. But you would say that even if we didn't get to that stage, if we came to the conclusion that they were wrong in their approach, they would therefore necessarily receive the case back in order to follow our lead.
Yes, my lady.
Yes, and Miss Patry, you nodded, so
yes, that's right. I mean, you absolutely do have the power to remit back to the Upper Tribunal, and in most cases, actually, that involve the DBS, that's what happens.
Right.
It's just that on the facts of this case, we say we've conceded that actually the matter should go right back to the DBS for a fresh decision, and that's the best, we say, the best remedy that the appellant can ask for. Now, it's a bit complicated, so I don't want to say too much about it at this stage. But if the matter was to be, the reason I say that's the best remedy is because if the matter goes back to the Upper Tribunal, we say, it would then be an error, assuming you found my learned friend's favour, you would then end up in a situation where you would have ground 1 was made out because it's conceded, and then 1 or more of grounds 2, 3 and 4 would also be made out. And we say that then the entire decision would be tainted and you would have to remit it back to the Upper Tribunal for effectively a new decision, a new hearing by a new tribunal. And that, of course, puts the appellant in a worse position, because then we're starting
potentially, because of course a new tribunal could find, as Mr. Fasley invites us to find, that it cannot be satisfied, even on the balance of probabilities, on the evidence before it, because of course they do receive, or can receive, new evidence, can they not?
They can.
That the facts are made out, even to the extent of 1 assault.
Well,
so, and if they did not find that they could be sure on the balance of probabilities, then of course the only conclusion that the tribunal can reach is that the name of Miss Kihembo must be removed.
But I'm afraid I don't quite agree, because of course there is no pleaded ground before you that the Upper Tribunal made a mistake of fact in respect of that finding, the remaining finding about that she was struck once. And
well, I think the new skeleton rather suggests that they did, Because if you look at the skeleton argument, it appears to me, on my reading, that what Mr. Fasley is saying is they do not explain how they can dismiss the finding that this took place over 3 months, but yet still remain of the view that they can be satisfied it took place on one occasion because there's insufficient analysis and there's insufficient reason to do so, and they give no basis for doing so. When I read the Upper Tribunal judgment, I see that the Upper Tribunal indicates that they had Miss Kihembo, who appeared and spoke.
Yes.
I don't think you did not appear, Miss Patrick. You did not. And there was counsel for the DBS, but there's no indication that there was any further evidence.
Other than oral evidence.
So was there oral evidence before the Upper Tribunal?
From the appellant, yes.
Well, was there evidence, or did she make submissions?
I confess I wasn't there.
No. Well, that's why. But you seem so sure.
She was asked. It's clear from the Upper Tribunal decision, for example, that she was asked to give any examples of situations where the SGP, the service user, had lied. It seems that she was asked that during the course of the hearing. And I'll be corrected if I'm wrong about that, but it appears from the Upper Tribunal's decision that she seems to have been asked that because they comment on it. So the answers to those questions must have been the giving of evidence, it strikes me. That must be right. But I'll be corrected because we don't have a transcript of the hearing and I wasn't there.
No.
My instructions are that she was asked questions by the representative for the respondent at the hearing before the Upper Tribunal. She was cross-examined.
Right, okay.
Melanie, on that point that my friend raises, the original skeleton argument, ground 2, 3 and 4, precisely does what I say in the renewed skeleton argument, which is that we challenge the findings of the Upper Tribunal in their entirety, save as to the positive finding, which is that it didn't find that the assault took place over a sustained period. And so that challenge is inevitably to a challenge of the adverse findings. And if you're with us on that point, my lady, you'll be open to this court to reserve the positive aspect of the findings. And if it so decide to remit the matter back for...
Would it? I think you're trying to have your cake and eat it there, Mr. Fasley, and you'll have to, certainly for my part, you'll have to take me to that in more detail. You see, Miss Patry is conceding that if we were of the mind that the Upper Tribunal were wrong in their approach, and therefore we were concerned about their findings, or the judgments of the court, whether there was concern about their findings, that it can be remitted to a different tribunal who would then look at the matter again. But Miss Patry then says, but if it goes back, then of course it's open to the new tribunal, or the different tribunal, or the same tribunal, to say, well, yes, it's right that we were wrong in our approach, or we must assume we are wrong in our approach, accept it. But we now consider all the evidence, and we find, in fact, that it was on more than one occasion. So you can't kind of bank what you've got.
That would depend, my lady, on the nature and the extent of the finding that this court makes. This court may say, for example, the approach was wrong in respect of the finding that the assault took place at least on one occasion, but that nonetheless the approach was right on the finding that there was no consistent or sustained abuse.
Well, again, you're having your cake and eat it, aren't you, Mr. Fasley? Because part of your skeleton argument is that the Upper Tribunal erred in failing to take an holistic approach.
Yeah.
And therefore, if you stand back and look at all of the evidence, and I'm paraphrasing your skeleton, so forgive me, one would come to the conclusion that you could not be sure on the balance of probabilities.
Yes.
Now, I don't know that Miss Patry is conceding that you can say to this court, because we're not a tribunal of fact.
Yes,
we're certainly not. That we can say, taking your argument against yourself, that logically you can say that one thing is right and one thing is wrong on the basis of what we've got.
Yes, precisely.
You can say approach, but if it's an approach, then...
May I interrupt just to say one more thing about remedy before we start, because since we're having this discussion, it's probably helpful for you to understand it and also for my learned friend to deal with it in his submissions. There are three possibilities open to this court in terms of remedy, just so it's absolutely clear. When I say possibilities, they're theoretical. We've discussed two of them. One is you can remit this right back to the DBS for a fresh decision on the basis that if you find that the other grounds are not made out, but ground one is made out as conceded, then you can say, well, the tribunal was wrong to say that this was not a material mistake of fact. It ought to, as a consequence, have remitted back to the DBS, and we're now going to just do that. So that's the first thing you can do.
And if you do that,
Yes.
that would be on the basis that the Upper Tribunal's factual conclusion
Yes,
that there was
would
one
stand.
assault but not 3 months worth
Yeah.
of assault stood. So
Yes.
that the only question for the DBS on that remission
Yes.
would be, given the finding of one assault,
Yes.
is it appropriate?
Indeed, exactly, because Section 4 tells us that if factual findings are made by the tribunal, then they're binding on remittal. So yes, that's right.
Yes, and we reach that conclusion only if we dismiss grounds 2, 3 and 4.
Well, 2's, in my view, identical to 1, but we'll come on to that.
Yes.
So that's right, exactly. So that would be the right course. And frankly, it might also be the right course even if you found that 3 and 4 were made out, because you might think that actually, given the DBS has conceded that that's the appropriate course, that actually it's a better remedy for the appellant. But we can have this argument in due course. That's the first thing. Jurisdictionally, as I've just outlined, you can also remit it back to the Upper Tribunal. I entirely agree with your ladyship that has to be a remittal to a freshly constituted tribunal on all issues. And that's why I say it's unhelpful, in fact, for the appellant to suggest that should be the course, because it's the worst of all worlds, because everything is up for grabs. Whereas if you remit back to the DBS, we'll be bound by the finding that she was not struck repeatedly.
Yes, but we're not in a position, are we?
Not at the
Miss
moment.
Battery, no, forgive me. In determining for the appellant
Yes.
what is best for her, because she may decide that it is best for her to seek to have the Upper Tribunal clear her.
Yes, indeed.
Because if it goes back to the DBS on the basis of one finding of assault, then it is still it's still possible, forgive me, for the DBS to say, well, given the nature of the circumstances, and we don't need to discuss that,
Yes.
one assault is sufficient.
As the Upper Tribunal did.
Well,
Yeah.
as sought to say that this was, that was
Because
the material
that-
issue.
Exactly, that's what the Upper Tribunal did. They said, well, the fact that she was struck once was enough, and she ought to be barred on that basis.
And that's why Miss Kihembo might think, well, in that case, I would rather like a tribunal to say I didn't strike her at all.
Yeah,
So
absolutely.
when you say it's the worst of all worlds, I mean, we are being a bit
I understand. I accept what you say. and
intrusive
absolutely.
on the free choice of...
Absolutely. And it will only arise if you decide that the grounds 3 and 4 are made.
But what's the third
The
option?
third one is, and this is, and I see it doesn't arise on the facts of this case, but it's raised in the replacement skeleton, so I have to address it with you now, is that you should order, if you find the grounds are all made out, or even 1 and 3 or 1 and 4, that you ought to direct the appellant's removal from the list now, right? That the errors are so grave that you ought to direct removal. Now, I'm going to say that is not open to this court on any basis, because, and I'll say it very briefly now, but I'll expand on this later, because, well, 2 reasons. First of all, there's a recent case, which I'll show you, JHB in the Court of Appeal, which explains precisely the circumstances in which you can direct removal, and they don't arise here. But I think perhaps most importantly, because there is just not the factual evidence. You would have to look at the factual evidence again and decide that there was a mistake of fact, a material mistake of fact in that finding. And that's just not something which I say is open to you at this stage.
No,
It's open as a matter of jurisdiction. Isn't it?
It's open as a matter of jurisdiction.
Lord Justice Lewis says in the JHB case
Yes.
that you have to show that that's the only rational outcome.
But in the AB case.
The AB
Yeah.
case, that nobody could nobody faced with this evidence could rationally come to the conclusion that anything had been proved.
Yes, exactly.
I understand that. Can I ask you one question about remittal to the DBS?
Yes, of course.
Who made the original decision in the name of the DBS, and would that person be involved in the remitted decision?
So the person who makes it is a caseworker, an expert caseworker at the DBS, someone who has, who's experienced and knowledgeable in matters of safeguarding and risk and so on for the DBS. Whether it would go back to the same person, I'm going to have to turn my back and ask that question, if I may.
Well, just speaking for myself, if this were a jurisdiction with which I'm much more familiar is employment tribunals, but it may also apply to other forms of disciplinary tribunal. If an employment tribunal had gone as far wrong first time round as the DBS caseworker did in this case on the findings of the Upper Tribunal, and the matter came to this court and we remitted to an employment tribunal, it would be to an employment tribunal none of whose members had anything to do with the case before.
Yes.
And if the outcome of this appeal were that the case is remitted to the DBS, speaking for myself, it would seem to me to give Ms. Kihembo considerable cause for complaint if it went back to the same decision maker.
I'll have to turn my back to ask the question, but I also have a point to make. Right. My instructing solicitor has sent an email back to the office to double check that, but I'm just trying to compare it to other jurisdictions other than the employment tribunal. So if, for example, this was a traditional judicial review, and, for example, someone challenged the decision of the Secretary of State for the Home Department, for example, if you were to decide to send it back to the decision maker, not to a court or tribunal, but back to the decision maker, so back to the Secretary of State for a new decision, then the decision would only come out in the name of the Secretary of State. Right? So the decision is that of the Secretary of State, and it would be challengeable on public law grounds in the normal way. So there would never be an indication from the court that the same caseworker must not be allocated. So I just want to be clear, the same situation arises here. If the decision ultimately was to remit back to the DBS would be bound to take into account, or to be bound by the findings of the Upper Tribunal. It would be bound to make a lawful decision. And because it's a fresh decision, the appellant would have a brand new right of appeal against any decision, as well as rights of judicial review, should there be any grounds that are not available on the statutory appeal. So I'm double checking the position as to whether the same caseworker, but the bottom line is it's not something which a court usually requires in these circumstances, because the decision is collectively that of the DBS rather than any individual decision maker within the DBS, and they would be bound to make a lawful decision.
Forgive my ignorance, Ms. Patrick.
Not.
What is for DBS? Is it a non-governmental?
Yes, it is. It's funded by the Home Office, but it's entirely separate, and it has its own directorate and legal team, and it makes decisions.
And how many caseworkers in practice are making these decisions?
That's a very good question. Quite a lot. I don't know if Jeff, do you know caseworkers? We're going to have to double check that, but there are a significant number. They have a board as well. There are all sorts of rules around escalating cases in particular genres and different types of cases. I mean, I was going to take, when it comes to, if my learned friend has not already done so, I was going to take you through the legislation and just explain all this a little bit so you understand, because it's a really unusual appeal jurisdiction. It's not a judicial review, and it's not a de novo hearing. It's somewhere in the middle. And the Court of Appeal has said, as you've seen in JHB and AB, has kind of explained what that means, but it's an unusual jurisdiction, so I'm really happy to take you through it.
Can you answer one question
I'm
just
happy
before
to.
we get on to
Yes,
Mr.
of course,
Fasley?
I'm so
Because
sorry.
no, not at all. It's my fault. I started all this off. But what you said is that the if you're right, and
Yes.
this obviously goes back to the DBS,
Yes.
because that's the least that can happen, because you conceded the appeal on ground one.
Yes, we have.
Are you saying in your skeleton that the new decision of the DBS would not take into account, as a finding of fact, the opinion of the Upper Tribunal that once is enough? Because they found that once is enough, and therefore,
Yeah, no.
if the DBS are going to be bound by the Upper Tribunal's findings of fact, would that be regarded as a finding of fact? Because
The
if
answer
so,
is
then Mr.
no.
Fasley's almost home and dry on that point,
No,
isn't
no.
he?
No, they aren't bound by that. The finding of fact that they are bound by is the finding that she was struck once but not repeatedly. Anything else is a decision as to appropriateness. And appropriateness, so whether or not it is appropriate to include the individual on the barred list.
Well, no, I mean, what the Upper Tribunal said
Yes.
was that it was not material. So
But they
does
were
that
wrong.
go to appropriateness,
Well,
or does it go to a finding of fact?
the bottom line is it would be wrong. The fact that their finding that it was not material was wrong, and that's why we concede ground one,
All right.
because it was material. So if that's right, it would be inconsistent with that concession for us to then come back and say, well, actually, once was enough. We would have to reconsider. It may well be that on consideration of the matter, the DBS might decide that once was enough. But it is not bound, and it would be unlawful for us to just say, because the tribunal said X, we're going to say X too, because we've conceded.
All right.
Can I just come back? This last thing I want to say, I promise, is about that third remedy, the removal from the list. I've explained, I think I'm going to explain in more detail in a moment, but the GHB case tells us now when it is appropriate to find that there's been a mistake of fact. But what's really important here, the reason why I say that remedy is not open to you here, is because if you look at grounds 3 and 4, they're about burden of proof and credibility. It would still be, even if you were to agree, they applied the wrong burden of proof, they adopted a wrong approach to credibility, it would still be possible for you to send it back to the Upper Tribunal, for them to correct those errors and still find that she had struck the service user on one occasion. So it is not open to you to say, we are satisfied, having found these errors, that she ought to be removed from the list, because those errors could be corrected by the Upper Tribunal. So that's why I say that is not a course open to you. And it isn't. Because the only reason why you would be able to say, okay, we are satisfied she should be removed on the list, is if you were satisfied that the JHB test had been met, i.e. that this was a finding so wrong that no reasonable
tribunal could have found that
Could
she
have
had
found it.
committed an assault,
And I'll show you
therefore,
the evidence. The evidence was,
Yeah.
was
well,
absolutely
we'll
there.
get there, and yes, but there are three
So those are
potential.
the three potential
yes,
remedies,
thank
and I
you.
thought it was important. And I'm so sorry. I apologise.
No. I
Yeah.
should apologise to both
Unusual.
of you for starting this off, but
Thank
it
you.
does help, certainly me, to know where we're going
Thank you.
now. So, Mr. Fasley.
Thank you. My lady, would the court like me to go through the facts briefly, or shall I get to the grounds straight away?
Well,
Just to summarise, the allegation was that she had, say, mistreated the patient over a period of months.
Yes.
The DBS caseworker was satisfied that she had.
Yes.
And the Upper Tribunal, will take us to the Upper Tribunal judgment, but
Yes.
they were satisfied in respect of the one occasion and not in respect of the rest.
Yes.
Tell us anything else that we ought to know.
No, my lord, that's pretty much it. And then there was a police investigation and social services getting involved, and I'll come to those in the course of my submissions. But those are the points. With your mission, my lady and my lords, I'll now go on to the grounds of challenge and the first ground. And I try not to spend too much on this because it is conceded.
Well, do you need to go to ground one at all, Mr. Fazley?
I do, my lady, because I want to take the court through the focus on the repeated nature of the sustained assault in the findings of the respondent, because that's relevant later to the other submissions I want to make. Thank you, my lady. Well, also, my lady, the document I'd like to take you through is at page 171 to 199 of the supplementary bundle. It is the barring decision process report.
171.
171, yeah. I'll come to specific pages in a moment. What the respondent said in that document, the focus was very much on the continued nature and the long duration of the assault. And the relevant sections are page 179 and the last section entitled Evidence Evaluation Outcome. You'd see there on the balance of probability finds the DBS that during the period of approximately 3 months ending on 18th May 2015, the appellant repeatedly hit service user, the complainant, and it goes on to give details. 180 is also that focusing continuation on that 3-month period as well. And then at 185, the last section again is a focus on a period of 3 months and referring to a spoon in a shoehorn causing red marks and bruising to the forehead, eye, knuckles and thigh. And it goes on to talk about the harm that has been caused. And 187, the last section, talking about the physical and emotional harm caused in the 3-month period being repeated again. 188, in the second section of the page, the second paragraph and third paragraph, again focusing on the repeated nature of the assault. 189 is also a reference to that at the top of the page. 192, the fourth paragraph, the DBS is satisfied the repeated nature and behaviour, the vulnerability of the service user and the physical and emotional impact it had on her makes it appropriate to bar Ms. Kihembo. And finally, 197, second paragraph, the first sentence, Ms. Kihembo has demonstrated a pattern of behaviour, making it more likely that the harmful behaviour may be repeated. That's page 195.
I thought you said 197.
Sorry, 197, yes.
It's the bottom of page 197.
And that's the fourth paragraph of 197.
That's just the representations.
Yes, that have been relied upon in the barring decision. What it says on page 97 is that Macur has almost demonstrated that during the final 3 months of her employment with Carers for You, she was unable to cope with gagging noises made by the complainant. The decision, my lady and my lords, on page of the 2nd of January 2020, which is one of the decisions, which is at page 100. 145 to 153. This is a decision in relation to the appellant being barred in the adult barred list. And on page 145, you'd see on the fourth paragraph, there is a reference again to the repeated nature of the assault, pretty much borrowing from the barring process decision on that point. And equally, my lords and my lady, within the decision of the 23rd of April 2020, similar references of the repeated assaults are repeated. Now, my lady and my lords, the decision of the respondent isn't where it says that if you had assaulted the complainant on one occasion, that too would be enough, and therefore the focus on the repeated nature of it. And that's why my friend perhaps rightly agrees that decision ought to be reconsidered. But I stress that point for later grounds, my lords and my lady.
Sorry, you were quoting from the letter beginning at 145, and where does it say once would be enough?
That's on page 146, my lord, the second page, the fourth paragraph.
In your representations, you claim.
Sorry, my lord, I think that might be the wrong reference. Sorry, my lord, it's page 145. Where it says what we have decided, fourth paragraph below there, the bullet point.
I've got during the period of approximately
Yes.
3 months, that one.
Yes, yes, that's a finding. And there is another place, I think, in the decision as well, that there's a focus, which is not in dispute, my lady, there was a focus on the sustained nature of the assault. Now, we know from the decision of the Upper Tribunal, I'll take you through it just briefly, because it will be relevant for later submissions, my lady. Paragraph 7, this is page 36 of the core bundle, where the decision can be found. And paragraph 7 is on page 39 of the core bundle. And the finding there is, as my lady rightly observed at the beginning of the hearing, which is that the court found that the assault did take place, but not that it took place over a period of 3 months. And there's a lack of clarity, so that the assumption one can make would be that what the court meant by that was the assault took place on at least one occasion, or once. And of course, the Upper Tribunal gave reasons for that finding at paragraph 10 and 15 of its decision. And for those reasons, I say in paragraph 11 of my skeleton that it was wrong for the Upper Tribunal respectfully to say that no mistakes of fact or mistake of fact was made by the DBS, which again is not in dispute.
But they did make a mistake of fact by saying it was a continual course of conduct.
They did, my lady, yes.
And that's what the Upper Tribunal says. The Upper Tribunal say that the DBS should not have found or they are not satisfied, the Upper Tribunal is not satisfied that this was a continual course of conduct.
But on page 36, my lady, this is the first page of the Upper Tribunal's decision. The last sentence says, DBS did not make mistakes in law or in the findings of fact on which his decision was based. DBS, his decision is confirmed.
I think we've moved on from that, though, because it's conceded
Yes.
that there was a mistake of fact which the Upper Tribunal identified. That is, that the mistake made by DBS was finding that this was a continual course of conduct.
Yes.
So, on that basis, on behalf of the DBS, Ms. Patry says it's got to go back to the DBS.
Yeah. Yeah. Yes, that's right. That's right, my lady. Yes.
Yeah. So I think you can take it that we're not going to say that Ms. Patry is wrong to make that concession.
Thank you. I'm grateful. Melly, just on paragraph 13 of my skeleton, just to talk a bit about the statutory framework of the appeal itself and the jurisdiction of the Upper Tribunal. This is page 17 of the authorities bundle.
So which skeleton argument are you talking about?
The replaced skeleton argument, the appeal.
Right, so take us to give us the
Page
number.
86.
Page 86.
Yes, of the core bundle.
Sorry, and you're going to take us to the authorities bundle
Yes,
now?
it's page 17 of the authorities. It's really section 4 of the Safeguarding Vulnerable Groups Act 2006, which I've quoted here in full. That is there in the authorities bundle. And really, in terms of the jurisdiction of the Upper Tribunal, paragraph 3 of section 4 says that for the purpose of section 2, the decision whether or not it is appropriate for an individual to be included in a barred list is not a question of law or fact. And at 5 below, it says, unless the Upper Tribunal finds that DBS has made a mistake of law or fact, it must confirm the decision of the DBS. In turning the page in my skeleton argument, it then goes to section, paragraph 6 of section 4, which is also on page 17 of the authorities bundle, which reads, if the Upper Tribunal finds that DBS has made such a mistake, it must direct DBS to remove the person from the list or remit the matter to DBS for a new decision. That's the framework there is as it established the jurisdiction for the Upper Tribunal to make that order if it is appropriate, and by extension to this court as well if the circumstances justify it to do so. Madam, my lady, I have referred paragraph 14 to the authority which my friend will take you to, which is relevant for this ground, which is page 124 of the authorities bundle, and it is the case of DBS against AB 2021. The authority of this court, CEF 1575. In terms of the facts of that authority, are that in that case the respondent was an organist and a choir master at a church. 4 girls made allegations that the respondent had engaged in inappropriate sexual conduct, resulting in sexual touching, and in one case sexual intercourse. He was placed on the barred lists, and the Upper Tribunal on appeal found errors of law, decided that it had the power to decide on the appropriateness of remitting on the lists, of remaining on the list in order removal of his name from the list. The respondent, DBS, appealed to this court, arguing that the Upper Tribunal had no power to consider appropriateness, and that it was a matter for DBS, and DBS was successful in that appeal. But there is, my lords and my lady, relevant passages that are of assistance. So paragraph 44, which is on page 124, paragraph 43, what that, perhaps my lord and my lady, the court may wish to read that, and perhaps I can take you through the submission.
So, what do you cite this for? What principle are you seeking to obtain from this? It's conceded that the Upper Tribunal cannot determine appropriateness of retention of the name on the barred list.
Yes. The point, my lady, is that if this court is with the appellant on the challenge that the Upper Tribunal was wrong to sustain part of the finding, then you'll be able to this court to order a complete removal of the appellant name from the lists, because this authority says the Upper Tribunal has jurisdiction in the right set of circumstances.
Yes, but the right circumstances surely are as if, taking for an example, there was evidence before the Upper Tribunal that on the day that an assault occurred, as could be established, it could also be proved that Miss Kihembo was not caring for SBJ on that occasion. Then if the Upper Tribunal had ignored that evidence and we regarded, as the Court of Appeal, that they had regarded or disregarded that evidence and that there was no other evidence, then of course that's a circumstance which would entitle us to say, and therefore we direct, that being the only evidence, that Miss Kihembo's name is removed from the list. But this paragraph that you've taken us to doesn't actually fit the circumstances here, does it, Mr. Fasley?
No, it doesn't, my lady. If you're not with me on the challenge that the adverse finding wasn't rationally or reasonably reached.
Well, that's why I wanted to discuss right at the outset whether or not it was open for this court to determine that the matter should be remitted because a wrong approach was taken. Because we're in a very difficult position, aren't we, Mr. Fasley, that we're not a tribunal of fact.
I accept, my lady, that if the fact-finding exercise is substantial, which it may well be on the facts of this case, then the appropriate course would be to remit it back to the Upper Tribunal for a fresh hearing.
Well, what facts do you point to where you say, I can demonstrate from the Upper Tribunal's judgment that they were wrong to make a finding that this assault occurred on one occasion, or that there was no evidence upon which a reasonable tribunal could have reached that decision, which is different. I know Ms. Battery would say you've got to be able to say, I think, there was no evidence on which they could have reached this decision. But you're not saying that, are you?
No, this is perhaps a later part of my speech. Just one other paragraph, my lady. I'll come back to this in a moment on this authority, and then I'll move on from this to another authority very quickly.
Well, hang on, but before you move on, do you challenge the fact that my lady has stated the test correctly? You don't have to say yes just because it's her, but it seems to me that you do have to show that the only the only finding that the Upper Tribunal could rationally have come to, could lawfully have come to, is that nothing had been proved at all. And that's the test, isn't it?
Yes, I mean that's how we would see it from that authority, my lord. The other authority that I'll take you to is a case where relevant conduct was found proven by the Upper Tribunal, but the Upper Tribunal still nonetheless ordered removal from the list, which takes a slightly much more flexible view of the test in this case, because in this case this is a far higher one. It's really paragraph 73 of this authority, my lord, that goes to the test. I'll take you to that.
33.
73, my lord.
73.
Yeah.
Well, that's the one which you've quite rightly quoted.
Page 132.
Yes.
Yes.
Yeah.
Yes, in this case, my lord, the court uses the term the only decision the DBS could lawfully reach in light of the law and the evidence. And in my submission, that interpretation of Section 4.6 of the 2006 Act is perhaps one that is very narrow. And
Well, it's binding on us.
it is, my lady, yes. Really,
I mean, it's logical, isn't it, Mr. Fasley, that if one looks at paragraph 73, if the Upper Tribunal should, as a reasonable tribunal, have come to the conclusion that somebody has been held responsible for something they could not have done because they were misidentified, then, of course, what the Court of Appeal can do is say the Upper Tribunal was so wrong and there's nothing else, and therefore we direct the removal of the name from the list. But if as in this case, the Upper Tribunal says, well, the DBS were wrong to say it happened more than once, but it did happen once, then unless this court is satisfied that that decision was completely wrong
yes.
on the facts rather than in the approach it took, then we can't order the removal of Miss Kihembo's name from the list, can we?
Yes, Melody, that is right. But I do seek to argue in the challenge that the position taken both by DBS but also by the Upper Tribunal is one that is unreasonable on the facts, because the facts do not justify a finding that the assault took place on the balance of probabilities.
Well, the difficulty there is that we haven't seen the ABE interview of SBJ. We haven't got a transcript of the evidence that took place before the Upper Tribunal. We've got the supplementary bundle with some of the documents that were before the DBS, but things have moved on. That there is prima facie evidence because there is an allegation of an assault.
Yeah.
Now, you seem to be saying in your skeleton argument, well, the Upper Tribunal went wrong for a number of reasons. First of all, they reversed the burden of proof. It wasn't for Mr. Kihembo to say why SBJ was lying. That does reverse the burden of proof. She's entitled to say, well, I didn't do it. And these are reasons that you should take into account in the holistic global assessment of the evidence to say that you cannot be satisfied even on the balance of probabilities. But she's not putting forward to the Upper Tribunal, I understand, or didn't, and she's not putting forward before us as new evidence. For example, the issue that, well, on Sundays I go to church, the assault actually took place on a Sunday, as the Upper Tribunal found, and because the Upper Tribunal have found that it did take place on the Sunday, and there is evidence that I go to church on a Sunday, therefore you can say that's the only evidence. So we're not in that position, are we, Mr. Fasley?
I acknowledge, Malina, I'm very grateful, the difficulties that there are in terms of the fact-finding exercise that we're required to make such an assessment. But I just make the point that it is open to this court, my lady, if it considers appropriate to order removal. But I acknowledge the difficulties in terms of...
Well, no. We cannot decide on appropriateness. It's not for us to say... The Upper Tribunal's findings permit us to say that it is not appropriate for the name to be on the list. That can't be so, can it, Mr. Fasley? Because you've already indicated that the Upper Tribunal can't make that decision, so we certainly can't.
Yes, my lady. Unless the Upper Tribunal or this court was satisfied that the only decision the DBS could lawfully reach in light of the law and the facts.
Well, there you've got it, and the facts.
Yes, as found by the Upper Tribunal. I see the point, my lady, and I'm grateful. My lady, can I just take you on that point to the other authority that I've said supports the proposition? That's an authority that postdates my skeleton argument. It's that the case of it's the authority, the case of AA against Disclosure and Barring Service, 2023, UK Upper Tribunal Authority, pages 63 to 84.
63, yeah.
And the facts in that case, I accept a very different, my lady.
Well, what was also different is that this particular authority, which is one of the most recent that's in the bundle, if not the most recent, we see that the Upper Tribunal held a face-to-face oral hearing at which the appellant gave evidence.
Yeah.
And there's some indication of the evidence that was given. So what do you take us to in this case?
Thank you. My lady, this was a case in which the appellant was a carer employed by an agency. DBS placed the appellant in the barred list following allegations. The Upper Tribunal rejected the appellant's denial that he gave the complainant tea rather than coffee, but found that the Upper Tribunal was uncertain as to why the appellant gave tea rather than coffee. It found that the appellant had also stated to the complainant that she was drinking too much coffee. It further found there was no evidence that this was done deliberately in order to upset or annoy her. It went on to find that the appellant failed to assist her colleague to reposition JC. The Upper Tribunal, however, did not accept two of the other allegations. And the Upper Tribunal found, ultimately, that the failure caused the complainant discomfort, which put her at risk of harm because he was restricting a person's choice, which may cause emotional harm. But a paragraph, for the reasons given at 62 to 66, my lady, it found that the relevant conduct was proved, but that it was not appropriate to keep the appellant in either list, in part because her failure was due to not knowing what to do, that she was not obvious to JC's discomfort, that there's no evidential basis that that the appellant generally lacks sympathy and is irresponsible and reckless. And really,
they state the test at paragraph 60, which I think follows from the decision of this court, which you just took us to.
yes.
We're entitled to direct removal from the lists only if we're satisfied that that is the only decision that could lawfully be made in the light of our findings. In this case, we're so satisfied.
Yes. It does, my lord. And really, the point that I'm hoping to make is that even where relevant conduct is found proved, and even where harm is caused to a complainant, as in this authority of AA, the Upper Tribunal still exercise that discretion in order to remove from the list. And I accept the facts are very different, my lady and my lords, in this case. But this was simply to make that point clear that the jurisdiction is perhaps slightly more flexible than suggested in the earlier authority, notwithstanding that authority is relied upon in this authority. And it may well have been that in AA, the DBS would have come to the same decision as the Upper Tribunal. But the Upper Tribunal nonetheless made that finding. And in paragraph 15 of my scholars on page 88, I made the submission in respect of the removal of name from the list that ought to have taken place by the Upper Tribunal. But I won't press too much on that, my lady, in light of your observations. Save us to say that paragraph 15 of the Upper Tribunal's decision, which is page 40, there is that finding that the complainants can develop but repeated. There was a lack of any sign of injuries, and that her recollection does not always accord with documentation, especially with dates. Those are all the submissions I wish to make in respect of ground one. Unless the court has anything on that point, with your court's permission, I'd like to move on to ground two.
Yes, do.
Thank you, my lady, grateful. This, my lady, is a complaint that the Upper Tribunal contradicted itself in Erdin law when it found that the respondent did not commit a mistake of fact, when elsewhere it has found to the contrary. There is an overlap between this ground and ground one. And again, this point is conceded. My lords, my lady, I need not to elaborate on this.
Would it help, Mr. Fasdian, if it just takes you too far off your kind of your plan of action, as it were? Do keep to that. But given that we're looking to see whether or not there's anything that you identify specifically to attack the Upper Tribunal's decision, do you want to take us to that?
Yes.
So I think you list in your skeleton argument, don't you, the fact that there appears to be inconsistency in analysis. There appears to be the reversal of the burden of proof.
Yes.
Perhaps you're also saying there's a lack of analysis. I don't know. But
thank you, Melody. In that case, shall I go straight to ground three? Because I think that's where the arguments.
If that's where you think the crux of your case is, I think that would help us.
Thank you, Melody. I'm grateful. My lady, the ground 3 is a complaint that an erroneous approach was taken by the Upper Tribunal in the analysis that it undertook when examining the evidential material, and that there is a failure of that appreciation. And then the first point is that there was a disproportionate focus on there being an obligation that the appellant should establish the truth of the alternative case that the appellant has put forward, as might be suggested generally in terms of who might have caused the complainant injury. Of course, the alternative case that the appellant put forward is that she denied the allegations, that she said that in part the injuries may have been self-inflicted, and that the allegations were therefore false and malicious against her. In the case of GF against DBS, UK Upper Tribunal Authority, the relevant page Case 180 is at 244 is where the case begins. I have the authority to fund them.
Is this on burden of proof?
Yes, yes, my lord. The page is 276 for this particular passage. And just for background, that was a case, it was an appeal by an appellant who was placed in the children's barred list by the respondent because he was convicted of one count of making an indecent photograph and was found in possession of an indecent image of a child. And the respondent found that he had searched for terms indicative of indecent images and that he sexually assaulted his 4-year-old granddaughter. And so in terms of the test, the passage I've quoted, 114, and it goes to that point, my lords and my lady, the burden of proof, there is no obligation on the complainant to establish the truth of any alternative case put forward.
But any failure on the appellant to establish such an alternative case does not itself prove
Yes.
case against them. That's what you want to put.
Yes.
Yeah.
Yeah. And just one other point, my lady. Paragraph just above that, paragraph 112 on the same page, refers to the passage from the case of REB children from the House of Lords. And there it talks about...
it's not confined, I can tell you, Mr. Fazley, to findings of sexual abuse.
Yes.
It's all matters that have to be proved before the court in a family case to establish the threshold criteria for making a statutory order. So it's wrong to say it only relates to sexual abuse cases. It applies to all cases where there has to be a finding on the balance of probabilities. And it's the simple binary test. Has something happened? More likely than not. If it hasn't, then you can't proceed on the basis that it possibly did.
Thank you. And my lady, it refers to a presumption of innocence. It gives the example that if a child says that his or her parents had abused, then the presumption would be that most parents would not abuse their children. And I say a similar presumption applies that most carers would not abuse. They assume they look after.
Yes, there has been subsequent authority to that particular REB case, which goes back to more likely the the enunciation by Baroness Hale, which is in 113. So you're looking at a balance of probability.
Yes.
There's nothing for Miss Kihembo to prove. She may put forward explanations, if she wishes to do so, in order to indicate why it is that the balance of probabilities has not, the standard has not been met. But it does not then become a burden upon her, the fact that she puts an explanation. That you've got the law on your side on that one.
Thank
Well,
you.
I think so anyway.
Well, I agree. Yes. Just make one other point about the burden of proof is the heightened standard of civil proof, which says that the higher the allegation, the more serious the allegation.
No, that's moved on, Mr. Fasley.
Has it?
That's moved on. That's why I'm saying there's another Reeby
I'm
case,
grateful
in
for that.
fact.
I'm grateful.
But you've got what you want here, haven't you? To establish that the fact that Miss Kihembo put forward possible reasons why SPJ was lying doesn't mean that she then bears the burden of proving that in order to knock the case out against her.
Thank you, my lady. Now I go back into the decision, which is where the real cracks of my arguments are. Paragraph 11 of the decision, page 39. My lady, my lords, have a moment to just read that paragraph.
You're saying this paragraph establishes that the Upper Tribunal went along the wrong road.
Yes, albeit, my lady, that it afforded disproportionate weight to that consideration of the alternative.
Well, what you're saying, in fact, is that this goes exactly to the point in GF that you've just taken us to, that the Upper Tribunal appear to be saying that because you put forward an explanation and you haven't made good that explanation, you haven't established why SPJ is lying, and therefore the case against you is proved. That's what you're saying.
Yes, my lady. In resolution, it's not for the appellant to prove why the complainant may have made the allegations, and that just because the complainant may be mentally competent does not mean that she was telling the truth, and equally, just because a person may be suffering from mental health difficulties does not mean that he or she would be lying or are necessarily more prone to being dishonest. The question for the Upper Tribunal that it asked itself, the Upper Tribunal did, suggests that disproportionate reliance was placed on the premise that the respondent is, that the complainant is mentally competent and she must therefore be telling the truth. And in my submission, that wasn't the most appropriate starting point. And it ought to have been in that paragraph about the substantive nature of and details about the complainant's claim, and not necessarily about the fact that she is mentally competent.
They did need to assess, did they not, whether they believed the account given by the complainant.
Yes.
And in that assessment, they necessarily are bound to take into account explanations put forward on behalf of by Miss Kihembo why the complainant's account should not be accepted. Is there anything wrong with them saying, let's look at why it suggested she might have lied, and rejecting that? Now, that doesn't necessarily mean that they've put the onus on Miss Kihembo. I mean, at the end of the day, they have to decide whether they accept the complainant's evidence or not. But in doing that, they must have regard to what they think of the suggestions put forward.
My Lord, I'm not sure if the appellant's case at any point has been that because of the particular vulnerability of the complainant or because of her health conditions, that was the basis of the allegation, because her defence appears to have been that she may have self-inflicted some of the injuries, that she hasn't been honest in respect of the allegation against her, and that the family has difficulties with her and vice versa. But I think the difficulty, my lord, is this, that it is open to the Upper Tribunal, and it is proportionate to say that the complainant acknowledging has mental health conditions, but that hasn't had an impact, or saying that because she has no conditions, she must be telling the truth. The problem is with the logic of that just because you're mentally competent, it doesn't follow that you must not be telling the truth. Equally, just because you're mentally not competent, it doesn't follow that you must be not honest. And then that's the difficulty there, my lord.
So that's one way that the Upper Tribunal may have gone wrong, by associating capacity with credibility.
Yes.
Right.
Yes.
But your point really is that it appears in paragraph 11, and when one reads paragraph 11, when pressed, PK gave another example of a false allegation of sexual abuse about another carer who was warned not to come back to the premises by SJP's brother. That was all. We would have expected there to be numerous occasions, perhaps involving petty matters. So this is what you're saying, indicates that the tribunal has completely lost track of what it was about, which was, are we satisfied on the balance of probabilities that the allegation made by SGAP has been made out on at least one occasion, as they found?
Precisely, my lady. And the focus of the appellant being able to give other examples of the complainant telling lies, in my speech again, is disproportionate. It's going outside the remit of not requiring the appellant to provide an alternative explanation for her defence, albeit giving too much weight to that point when the law doesn't require her to have an alternative explanation for that. That is the point, my lady.
When you go back to Baroness Hale's judgment in Re B, that the fact that the points put forward by, as it were, the defendant don't stack up doesn't mean that the case against them is proved. That's what it comes to, isn't it?
Yes.
But whatever we think about the logic of that was all, a complaint about sexual abuse, it appears you would submit that the tribunal have fallen into the trap of saying, you've raised these matters, you can't prove them, therefore the case against you is proved.
Yes, my lady. That's the point, my lady. I think that's later in my grounds, but yes, that's precisely the point that I'm trying to.
Yeah.
Thank you, my lady. And just the final one or two points on ground 3 is that this is paragraph 22 of my skeleton, page 92 of the core bundle. My lady, the complaint is that there's a failure to consider the appellant's evidence contained in her letter of 14th October 2019, which is at pages 90 to 95 of the core bundle, albeit a supplementary bundle, sorry. Page 90 to 95.
And 94.
90 to 95.
Right.
And in that letter, my lady, is the explanation that the appellant had given for why there may have been what the motive might have been for the complainant to make the allegations, and those would have been relevant for my submission to have been considered by the tribunal, not necessarily in terms of the burden of proof so much, but more when assessing the reasons why the appellant is innocent, or the reasons why the complainant may or may not have made the allegation. In that letter, my lady, at page 91, that's the next page, this is a letter written by the appellant. You would see on the first, second, and third paragraphs. I just read out the relevant bits to you, my lady, and this content is not in dispute. What the appellant had said in that letter, that 5-page letter, is that the complainant's parents hated the appellant, that they wished that she was dead, that the complainant's mother had become angry because the agency had told her to stop asking the complainant for money after the appellant informed the agency about this. The complainant's father stated that the appellant is, and the swear word, we don't need that, this is a quotation, and that the complainant's mother had accused the appellant of being a thief who had stolen the complainant's money. This is a brief summary, but it's much more detailed. Those points, my lords, in my lady, in the decision, there doesn't appear to be an analysis of this evidence. This was the appellant's, if you like, submissions or statement to the Upper Tribunal, first made to the DBS, but then before the Upper Tribunal for the appeal hearing. And those specific points, unless the court wishes me to go to the specific paragraphs, my lords and ladies, those were the points that were made.
Do we have page 4 of this letter? Oh, yes. It's pages 4 and 3.
Just inverse.
Yeah, yes.
Yes, I see. Thank you.
It does appear to be, my lady, a proper focus in any material way within the decision of the Upper Tribunal to this evidence of the appellant that was put forward in her defence. And in the submission of paragraph 23 of my skeleton, that there is insufficiently equal and fair treatment of the appellant's account in comparison to the account of the complainant. And therefore, the submission being that it was wrong for the Upper Tribunal to sustain that adverse finding and to keep the appellant on the list. Moving swiftly on, my lady, my lords, to ground 4, which is the final ground of challenge. And that really builds on ground 3, and it complains of an erroneous approach to credibility and a failure to provide adequate reasons.
Whose credibility?
The appellant's credibility.
Right, so ground 3 was about the complainant's credibility, and this is about the appellant's credibility.
They're sort of intertwined, my lords and my lady.
Yeah.
Yes,
Okay.
yeah. So they get to both parties. And at that point, my lady, one thing that does strike me is that the appellant, the respondent, rather the complainant, wasn't produced before the Upper Tribunal to be cross-examined, because that was a star witness of the respondent, but there was no opportunity given to the appellant to ask questions or to cross-examine that witness. And so that's just a background point. I know that the court can consider other forms of evidence. It is up to you to do so. but that has to be seen in light of the fact that the appellant never had an opportunity, as natural justice would dictate, for her to be able to put to the complainant's star witness that you say this, but you also, for example, gave gifts when her employment came to an end or thereabouts. Why did you do that? Or that you had these problems with your family. You initially denied, for example, that it was the appellant who hit you, but later on you withdraw that allegation and you said, or that assertion, that it was the appellant. So there was no such opportunity given to the appellant. And that's the background before the Upper Tribunal. I'm sure our friend will say more about the procedure before the Upper Tribunal and these types of appeals. But one can't ignore the fact that there was that defect in the context. Now, the Upper Tribunal's findings in my submissions are, in many respects, speculative and appears to be based on mere suspicion. And this is the reason why we say, my lords, my lady, that the sustainment of that adverse finding in its partial nature is difficult to sustain on the evidence and on the analysis. Now I go back, my lord, to the authority which I've cited in paragraph 24 of my skeleton, in paragraph 114 of the case of GF, and quoting that passage from the skeleton. It says, findings of fact must be based on evidence, including inferences that can properly be drawn from the evidence, and not on mere suspicion, surmise, speculation, or assertion. And applying that to the facts of the Upper Tribunal's decision, at paragraph 25 of my skeleton, I refer to the judgment at paragraph 10, the Upper Tribunal's decision, and it's really where it says, the last sentence, paragraph 10, where it says it's in PK's best interest in favour that she recorded what was visible on 16 and 17 May, but it was visible and it would have been suspicious if she had not recorded it. Now I can take you to the passage from the diary, but that is not in dispute, my lords and my lady, of what is stated therein. The difficulty with this value judgment or finding, perhaps, is that it is speculative, because if the appellant had not made these notes in her diary, then she would most likely have been accused of acting in breach of her usual practice of making notes, particularly given that she has kept a diary with some degree of irregularity. And more significantly, she's likely to have been accused to have attempted to conceal what others saw, and as a professional carer, it would have been very unusual not to make a note of the injuries. The appellant was simply doing her job, and I make the point that if she wanted to hide or conceal something, then it is likely that she would not have made the notes, or certainly not refer to the injuries. But again, the complaint really is that the finding is speculative, and really...
Mr. Fazley, what was the particulars of the complaint? The particulars of the complaint were that SBJ said that she had been hit with a shoehorn and a spoon.
Yeah.
Did she say where she was hit? Because you see, one of your better points may be that in paragraph 10, the Upper Tribunal, having referred to one occasion on which there was a visible sign of injury that was explained or could be explained in one sense by SJP scratching her eye with bluntly cut fingernails. The Upper Tribunal then go on to say it does not matter precisely what injuries were sustained, but it may be pertinent if one puts it against the allegation made. Is that a point you want to make to us?
Yes.
Rather than whether or not notes were made?
Yes, my lady, precisely that point, that whatever the injuries were, the Upper Tribunal was required to consider whether they were consistent
with the allegation.
With the allegations, yes.
So what was the allegation? Can you remind us?
Yes, of course.
Apart from the SJP being hit with a shoehorn and a spoon.
If it helps, there's the detail of it at page 32 of the supplementary bundle. That's the extended police report. And following on from there, there's quite a lot of detail after that point, but that's where it starts. And the nature of the injury was a red mark. The initial injury notice was a red mark on her forehead.
Yes, but where do we get the detail of the complaint made as to where SJP said she was hit by the shoehorn and the spoon?
So if you look at page 32, the second full paragraph, which VIW1's family, which VIW1 appears to be SJP, there's a transcript because they recorded the conversation. The family recorded the conversation. There's a transcript.
Do we have the ABE interview?
We haven't got the full transcript of it. We have a note of it in here. Let me just look up the.
What would have been before the Upper Tribunal? That's more important, isn't it?
The supplementary bundle contains everything that was contained.
Right.
Yeah. So. There is a reference. There is her. Give me 1 minute. I'll find the reference.
Well, here, at page 40,
Yes.
the police report says, this is an allegation of assault where the victim has alleged that her live-in carers assaulted her by hitting her with a shoehorn. There were no other persons present at the time of the incident. However, the matter was reported to social services and police after the victim went to visit her family and the bruising was noted.
Yeah.
So we can get a date from that. Is that the same date as the notes that were made by Miss Kihembo?
Page 36. Sorry, which page were we on just now?
18th
40.
May 2015.
Do you see the interview with her by the police is set out at page 36 of the supplementary bundle.
Thank you.
And you see DC Rothwell and DC Potter attended her home address to carry out an AD interview, and then there is a summary of what she told them. And that has all the relevant dates. So
Sunday the 17th of May 2015, the allegation was she made an involuntary noise, hit with the shoehorn, causing injury and bruising and swelling to her right eye.
yes. It had happened also on the 15th of May, but if you see Saturday the 16th of May, she went to see her family and her brother noticed the injury, and when she attended, she was not going to tell her family if she was frightened the same thing may happen again.
Well, that's knuckle to the hand, isn't it?
Yeah, exactly.
And forehead, it's not the eye. Right, there we go, Mr.
That
Wesley.
assisting.
Thank you. I'm grateful, my lady. My lady, in my lords, the other paragraph is paragraph 11, of the decision, which I took you to earlier, but just to refresh the Mallo's memory on that passage. And that relates to the points that the tribunal would have expected more than one occasion of the complainant telling lies, and more information about the allegation of sexual abuse against another carer, and that the finding that she doesn't lie to get people into trouble. That's the three points of that paragraph. Now, my submissions are, respectfully, that the Upper Tribunal appears to restrict much of the credibility issue primarily to this question of why you should not believe the complainant because she's mentally competent. I mean, I made that point about the competence issue. I won't repeat that, my lord. That's paragraph 28 of my my skeleton. But I do say that the Upper Tribunal failed to adequately ask itself the same question as to why the appellant, who has a unblemished record, is educated, has so much to lose if she commits a wrong, would commit the alleged unlawful conduct. And this is particularly because motive was found. Paragraph 14, the Upper Tribunal failed to find a motive for the appellant, at least causing the complainant assault on one occasion, which is the finding it made. But no motive was found by the Upper Tribunal. And to the second point in that paragraph, that the point that she doesn't always lie, in my submission, nobody in general ever always tell lies. And the complainant, the fact that the complainant doesn't lie all the time, doesn't necessarily mean that it favours her account. This is because, and in particular because the Upper Tribunal accepted that she lies on occasions. And that is an important point. And we know that she had admitted, the complainant had admitted that she herself caused an injury to her right eye. This is what she said initially. And if that was untrue, which it turned out that it was, then clearly that is something that should have undermined her credibility, or the account that she had provided in the written form to the Upper Tribunal. But that part of the evidence wasn't featured in adequately, which undermines the finding that she must have been telling the truth, that at least on one occasion she had been assaulted by the appellant. And so there is no focus on the adequate focus on the fact that she initially said something contrary to that which she said later. And further, the Upper Tribunal found that complaining lies for a particular purpose. It does not involve getting anyone into trouble. In my submission, that is difficult to reconcile with the facts. Because if I can take my lords and my ladies to a letter from Carers for You Limited, which is dated the 11th of November, and which appears at page 123 of the supplementary bundle, and it's really the second second paragraph and the third paragraph, last sentence, where the appellant's employer has stated to the Disclosure and Barring Service that when they took the complainant, they were informed by the social worker that the parents weren't allowed to visit her. The social worker also informed us that the complainant had made some allegation against her mother but failed to show up in court to testify. And it goes on that that I've also received reservations from some other care workers who worked for the complainant, and they weren't comfortable with her because of her mannerism, and she used to talk ill of her parents. And the last paragraph on that page, it goes on. However, the complainant left the meeting rather early as her dad turned abusive to the extent of disowning her. And in my submission, if the complainant was capable of getting her own mother to court based on some allegations that she may have made as the social worker, as this report appears to suggest, this letter, then that seriously undermines the finding of the Upper Tribunal that she doesn't lie to get people into trouble. I'm not suggesting that she was lying on the occasion of whatever allegation she may have made against her mother, but she didn't turn up to court, as it appears from that document, and she had certainly caused, it would appear, her mother to be required to attend court. And of course, the other point about the Upper Tribunal expecting there being numerous occasions in which the complainant had lied and accepting more examples. That goes back to the earlier point, my lady, about the test and there being not a reverse burden of proof on the appellant, effectively. And of course, it doesn't follow logically just because there has been numerous occasions of somebody lying that therefore they must be lying about this occasion. The fact that she may have lied once is a relevant factor, and there is no such requirement, and no need for a disproportionate focus on this point that the appellant had to establish and provide evidence that the appellant had lied and lied on many more occasions. For the Upper Tribunal to have found the appellant credible in her denial of the allegation against her, or indeed equally to have reduced the weight.
Well, they didn't have to believe Miss Kihembo, did they, Mr. Physician?
No.
All they had to do was to say, we are not satisfied on the balance of probabilities. That
Yes.
doesn't mean they make a definitive finding in favour of what Mr. Kihembo was saying. But
Quite.
your point is that there were obviously things in the supplementary bundle
Yes.
that the tribunal overlooked or did not articulate.
Yes.
And you've taken us to one of them, which is the allegation that SJP made an allegation against her mother.
Yeah.
And then that did result in criminal proceedings, but Miss SJP did not attend as a witness.
Yes. Yes, my lady. That's the point in that section. And I agree entirely, my lady. The point isn't about whether or not she was believed, but it was whether or not it's more likely than not that she did commit the conduct that was alleged against her. And so the point was the focus on there being many more instances of the appellant providing evidence of in which the complainant had lied. In my submission, it's perhaps an unusual way to adjudicate upon an issue. because it simply doesn't need to be many instances of a complainant lying for the tribunal to then make a finding in a way that is proportionate and reasonable to the evidence from both sides. And in paragraph 12 of the decision, page 40, the core bundle.
Can you help me where the Upper Tribunal found the basis of the final sentence in paragraph 12, given that we've just seen something where Miss Kihembo was told not to hand over money in the presence of the brother?
Yes.
Can you point us to it in the supplementary bundle?
Yes. Sorry, Melanie. The question is, I'd be grateful if you can repeat it.
Yes, sorry, I'm
That's right.
not clear. So, in paragraph 12, the Upper Tribunal are saying another possible explanation is that SJP's family manipulated her to accuse PK.
Yeah.
And we've seen something of that suggested in the supplementary bundle. But the letter that you took us to, which was from the manager of Miss Kihembo,
Yeah.
was to the effect that Miss Kihembo had previously reported that the mother was seeking to obtain monies from SJP.
Yeah.
And that she, the manager, had told Miss Kihembo not to hand over the money in the presence of the brother.
Yes.
And the brother, and you didn't take us over the page, but I looked ahead on the letter, and over the page it says that the brother admitted the mother had taken the £500, but he said he would pay it back.
Yes.
But I'm just asking where the last sentence of paragraph 12 comes from. It says, moreover, SJP's brother had been protective of his sister when their mother was trying to obtain money from her through PK, so it would be unlikely for him to be manipulated to persuade SJP to make and pursue this accusation.
Yes.
And I'm just wondering where it is in the supplementary bundle, because speaking for myself, I haven't looked at the supplementary bundle,
Yes.
because one doesn't usually, unless directed to it in pre-reading lists.
Yes. Yes.
So if it's in there,
Yeah.
I'm just wondering where it came from.
Yes, it's a very valid observation. I'm very grateful for my lady. If I don't have any.
If you can't put your hand on it straight away, Mr. Fasley, let's move on, and then you can come back in due course to that when you've had the
Thank you.
chance to look at the supplementary bundle.
Thank you. I'll just make a note of it. Thank you. And the point I made about that passage at paragraph 33 of my skeleton argument, that the Upper will fail to sufficiently consider that the complainant's family may have wanted to inflict harm upon the appellant, given how much they disliked her for the reasons set out, for example, in the Appellant's letter of 14th October 2019, which I took
Yes,
my
you've
Lord
taken
Lady.
us to that.
Yes, and that was, pardon, we say not considered by the Upper Tribunal. And secondly, just because the appellant was leaving, that doesn't mean to say, in my submission, that the complainant and her family would not have wished to inflict harm upon her because of the difficulties they've had in the past with her. And so that was a possibility to which the Upper Tribunal doesn't appear to have been alive to. I've already considered one part of the evidence, which is that she's leaving, that's what they wanted an Indian carer, but doesn't then consider that because of the previous difficulties that the appellant has had with the family and vice versa, and with the appellant has had with the complainant has had with her own family, that may have been the reason, potentially, for them still wishing to cause her some difficulties. Because from one logic, my lady, is that they would have been less likely to cause her harm when the appellant was caring for the service user, because they didn't want the care to be disturbed because of the complainant's exceptional physical conditions. It was less harmful to them and perhaps more convenient to make the allegations when they knew that the appellant was leaving, because at that point the appellant was of no further use to them. But that possibility, which is entirely logical, doesn't appear to have featured in to the Upper Tribunal's assessment at all. And that is consistent, my submission, with the allegation that they had made, as the appellant says, that the appellant was a thief. He was still in the complainant's money. Paragraph 13 of the Upper Tribunal's decision this is the Upper Tribunal accepting that the complainant had bought her presents for her baby, and they're speaking to her on the phone and wanted to visit. Upper Tribunal noted that the appellant presented this evidence as casting doubt on the complainant's allegation. Once it accepted the appellant's evidence about these actions of the complainant, which postdates the allegations, if I'm not mistaken, or at least in part, they do. The Upper Tribunal went on to say, we do not, though, consider this cast doubts on the reliability of the complainant's account. There is no necessary inconsistency in her behaviour. It's plausible that she was grateful for what PK had done during their time together, which after all had gone well until the end. There was no reason for animosity against the baby. In my submission, the Upper Tribunal is looking at this from one angle, which is that no inconsistency. She may have been showing her gratitude and gift for the baby, and the telephone call and her contact is not inconsistent with that. But the Upper Tribunal has failed to look at the appellant's case adequately, which is that those actions, and again, I make the point that there was no opportunity to cross-examine the complainant, that they also equally demonstrate a behaviour that is not consistent with the allegation as she made them that over a period of 3 months, the appellant had regularly and seriously assaulted her, using a weapon in the form of a shoehorn and a spoon.
You said that the behaviour wasn't consistent with her account of having been assaulted over 3 months.
Yeah.
But the Upper Tribunal has not accepted that she was assaulted over 3 months and has only found one assault. So it was a question on your appeal should be, shouldn't it? Whether this fact, which is not disputed, that the complainant had bought presents for Miss Kihembo's baby, cast doubt on the suggestion that Miss Kihembo assaulted her once, not over 3 months.
Yes, my Lord, precisely. I was just looking at the context in the way that it was made by the complainant. So her complaint was over a length of period of time, and the Upper Tribunal was looking at it, her conduct in light of what she said overall. including the length of the assault. And so looking at her evidence as highest, and we know that wasn't found to have been established by the Upper Tribunal, but looking at it at its highest, in that account, in my submission, this finding is in balance, in that it's failed to give sufficient regard to the appellant's evidence that she didn't cause the complainant's behaviour cast doubts on her actions, because if she had assaulted her over a period of 3 months, it'd be difficult that she would. Of course, there are people that would be grateful, that may well appreciate people even in circumstances where there has been abuse, but it makes it more unlikely, and so the Upper Tribunal was, in my submission, obliged to look at this issue properly and adequately, and to explain, perhaps a bit, with some further details as to why it found that behaviour is not inconsistent or doesn't undermine her account, other than merely to say that she was demonstrating gratitude for the earlier period in which there was no abuse.
But Mr. Fasley, you've said in your submission that it's equally consistent. And if it's equally consistent, it means that it was open to the tribunal to find, as a reasonable tribunal, that this does not throw doubt upon the reliability of SJP's account. It's not your best point, is it? Because they actually explain why it is that they think that this part of the behaviour, which they accept on the evidence of Miss Kihembo, occurred, may have happened, that there had been gratitude for the earlier times that Miss Kihembo took care of SBJ, which had gone well.
Yes, my lady, that's... my submission was more, my lady, that well, it's certainly open to the Upper Tribunal to make that finding, that...
Well, if it was open for them to find it, then you've got no appeal, have you?
But with that
point...
Yes, my point is, my lady, that they haven't properly considered, inadequately considered the appellant's explanation that it does cast doubt on the allegations.
Well,
in the
get
context
that from paragraph 13?
Yes.
Because what they say is, we do not, though, consider that this casts doubt on the reliability of SJB's account, which suggests, certainly on my reading, that they have considered whether it does.
Yes.
And have determined that it doesn't. And you've already said that that was open to them.
Yes.
That there could be reasons why SJP had made presence, had phoned up Miss Kihembo,
it was just more, the reasoning itself, that we're looking at the balance of probabilities that she may have been grateful for the earlier service in the context of an allegation of a 3-month period of abuse. I mean, that just seems perhaps less likely. But,
all right, what's your next point, Mr. Fasley?
Thank you, my lady. Is paragraph 17 on page 40.
There's nothing really wrong with that, is there?
In this paragraph, my lord, the Upper Tribunal says that there is a frank admission by the reviewing officer that there were further inquiries that would have been pursued had it not been for the delays. And the respectful complaint is that if you look to the report on the whole, and I'll take you to that in a moment, it made other points which supports the position that the evidence was lacking. It's page 39 of the supplementary bundle. And the second paragraph after the first line, where the line starts, the police says this offence consists of one word against the other. The injuries have been explained and accounted for by the suspect, and her account cannot be disproven on the evidence that we have. And there are no further lines of inquiry which can be followed. It then goes on.
But it says, in different circumstances, I would be asking for further inquiries to be made, such as the history of the victim with regard to making previous allegations. That's not mentioned by the Upper Tribunal, is it?
No, my lady, it isn't. No, and that was one of the point that, because the appellant's case was that the complainant has complained against another carer. I think it was sexual.
Yes, you've taken us through that. But the point my lord makes is that the tribunal saying that actually, if you look at the decision, it was all about the delay. The police officers in a state of high dudgeon, quite understandably saying this is 3 years on.
Yes.
Miss Kihembo has been chasing us for a decision. She's been denied maternity pay, and we're still in the same place that we were, and the CPS have finalised their decision. So how does that help you?
Thank you, my lady. I think it helps in the sense that, as I've cited paragraph 37, there are other bits of the report which does support the proposition that the evidence wasn't enough. I accept the point about the delay,
Yes,
my lady.
but you do have a point, do you not, that they did not mention that the further inquiries could also have produced evidence against
Yes.
the veracity of the allegation.
Yes.
Is that the point you
That is the point, my lady. Yes.
Yeah.
We should make. And that's a point that I've made, my lady, at paragraph 38 of my skeleton argument.
Yes.
And just one point, my lady, on page 39 of the supplementary bundle, the paragraph just above the OIC says we do not have enough evidence to charge. There is no RPOC. All significant material lines of inquiry have been completed. And the point just being simply, I appreciate what the police says about the delay, my lady, and I don't for a moment underestimate that. But there's also that passage which says that all significant and material lines of inquiry have been completed. We does suggest that the significant materials have been looked into, as the police considers this to be.
I assume that RPOC is reasonable prospect of conviction.
I don't know
Yes.
why. Yeah, I'm grateful.
Yeah.
Thank you. My lady, just sort of the final few points. Paragraph 39 of my skeleton argument complains that the Upper Tribunal has erred in placing reliance on the findings. Erred in placing reliance on the evidence of MN, who was another carer. This is the carer who had not seen or witnessed the appellant being assaulted, but who had been told by the complainant, the complainant being assaulted, had been told by the complainant of the assault allegedly having been implemented by the appellant. Her evidence was hearsay evidence. And her evidence my lords and my lady, can be seen. There was no witness statement from her, and she was not cross-examined again in the court. By this point, her evidence was raised as part and parcel of the respondent's case, and that can be seen. First of all, on one point, this point was raised in the grounds of appeal to the Upper Tribunal. That's page 4 of supplementary bundle. If I can take you to page 4, so that this is not a new point in the sense that the Upper Tribunal wasn't aware of it.
Did the Upper Tribunal mention it?
It didn't engage with.
Well, did they place any reliance upon MN at all in the judgment?
I haven't read it now. It doesn't appear so, my lady.
So, do you really want to put up an Aunt Sally to knock it down?
No, my lady, I'm grateful.
No, if there is a good reason, do proceed, Mr. Fasley.
Yeah. Thank you, my lady. I think the point was more, my lady, that if that was hearsay evidence, which we say it was, and there was no witness before the Upper Tribunal from MN, other than the evidence that had been put in by the respondent from what she had said, and that formed the respondent's case, then it ought to have been treated with sufficient caution when assessing whether or not the complainant has demonstrated or the respondent has demonstrated that the appellant was responsible for the conduct. I'll just take you through, my lady, the passages in the respondent's case where weight was given to MN's evidence.
But by the DBS?
By the DBS.
But the DBS decision can't stand. That's accepted.
Yes.
So the question is, unless what you're about to show us tends to undermine the Upper Tribunal's conclusion that the shoehorn or spoon incident was proved, it doesn't help, does it?
I see, my lord. What the respondent's case was that, based on what the complainant had told MN, they formed. This was part of the analysis. They formed the view, including by listening to what the complainant had told her family, which was video recorded. It was all of that evidence put together that led them to the conclusion. And when the Upper Tribunal was assessing the evidence from DBS in its entirety, including what MN had told DBS, then the Upper Tribunal said, well, actually, the burden is discharged to that limited fashion. And we say, because MN featured as an important part of the respondent's evidence, that evidence was defective because it was hearsay, there was no witness statement, and there is no assessment of that defects within the Upper Tribunal's judgment.
But if the Upper Tribunal disregarded that evidence, then how does this assist you?
Because in reaching his decision, my lady, the Upper Tribunal was required to look into.
Yes, but it's against you. The evidence is against you. So why do you want us, as the Court of Appeal, to have regard to the fact that the Upper Tribunal disregarded evidence that's against you?
I see that point, my lady, but that evidence, we say, had defects, and it was relied upon by the DBS itself in reaching its own decision, without having to have...
But as my lord's already said, that's not our concern at the moment. Our concern is to look at what the Upper Tribunal did.
Yes, my lady.
But her evidence, MN's evidence, only goes to the question whether SJP did accuse, at the time, Miss Kihembo of having been responsible.
Yes.
Because, as you say, MM wasn't there,
No.
so she can't give any evidence
Mhm.
as to whether the assault took place.
Yeah.
All she can say is, this is what I was told by SJP. But we know that there was video evidence that SJP had already told her parents that
Yeah.
Miss Kihembo had assaulted her. So what does it really add? The question for the Upper Tribunal was whether they were satisfied on the basis of the evidence that SJP's accusation was established on the balance of probabilities or not. But for my part, I don't see that the fact she told their men adds very much to the fact that she told her parents.
My Lord, I have maybe just to refresh what Emin said to myself, and then I can move on to that point. Thank you. Great.
Mr. Paisley, in other jurisdictions,
Yes.
the evidence of MN would be admissible as recent complaint.
Yeah.
And it doesn't, as my lord says, prove the allegation, but it's something that a jury can take into account
Yes.
if there is an allegation made against the complainant that there is recent fabrication.
Yeah.
Okay. But the point for us is that the tribunal did not rely upon that, it seems, and you're complaining about it. So, whatever the route to the Upper Tribunal, unless I've missed something in the Upper Tribunal's judgment, it doesn't seem to me that they placed any reliance upon it at all.
Yeah.
So that, as I say, it's an Aunt Sally you're setting up to knock down.
Thank you, my lady. I'm grateful, my lady. May I just have that moment, my lady, to look
Of
at?
course,
Thank you, I'm grateful.
yes. Is this another thing to put on your list, Mr. Paisley?
Yes,
And come
my
back
lady,
to.
yeah, my lady. I have found it, and I agree with my lords, my lady. But just add one submission only. My lady, on page 176 is of the supplementary bundle. The second paragraph, when the men arrived, the injury to the complainant, right?
Yeah, so what do you want us to do about
Just
that?
simply the point, my lady, that in that paragraph it is suggested by DBS that this information, when taken in conjunction with plaintiff's explanation and corroborative evidence provided by men and in part by the appellant, makes the complainant's version of events more credible. And the point was the reliance was placed on that evidence, but I appreciate and accept that the Upper Tribunal doesn't appear to have engaged with that evidence, and so
No.
I accept that point. I'm grateful for the.
So is that your ground 4?
Yes,
With?
that is my lords and my lady. Those are all the points that I have made, and I'm grateful. My lords and my lady, there was the preliminary issue of the appeal being academic on the issue of relief. That was addressed in the submissions.
Well, before we get there,
Yeah.
may I just ask, do you accept, Mr. Fasdy, that if you were able to persuade this court that the Upper Tribunal was wrong in its approach and that we should remit this matter to the Upper Tribunal, do you now accept that that would mean that the Upper Tribunal would be required to undertake the hearing or the review de novo, which means that it could make findings other than the findings made by this upper tribunal. That it's open territory, in other words.
It is certainly open, my lords and my ladies, to this court to make that order.
Yes, we know that.
Yeah.
Do you accept that if we were persuaded that the upper tribunal was wrong in its approach, that if we remitted it to the upper tribunal would be required to undertake the whole exercise afresh, and therefore may make findings against Miss Kihembo that go beyond the one occasion? Do you accept that?
My lady, the appellant's expectation, well, hope is that this court will set aside the decision of the upper tribunal and preserve that finding that is favourable to her. And the reason for that, my lady, if I may respectfully address you, is that we don't complain, for example, the finding that the judge found there was no motive, for example, established. We're happy with that finding. We accept that there was no finding on the assault being sustained assault. Where we have problem with the judge's finding, my lady, there's been no cross-appeal on the positive finding to be challenged by my learned friend, is the sections of the findings that goes to the sustainment of the adverse finding. That's what we challenge, my lady. And the hope is, in the absence of a cross-appeal to that positive finding, that should be maintained, if at all possible. Of course, I appreciate that my lords and my lady may take.
Do you have any authority for that proposition, Mr. Fasley, that we are entitled, despite your argument on the logic of the upper tribunal's findings not being consistent, either in the evidence or in their consideration of the board's conclusions, that it is possible for us to remit on such a limited basis
To the Upper Tribunal.
to the upper tribunal? Sorry.
Thank you,
The
my
upper
lady.
tribunal.
No, I don't have an authority. The point was, my lady, that look, I appreciate, my lady, that the court may reach the view that the credibility assessment and the approach on the whole was such that nothing can be preserved. I acknowledge that, my lady, that as a possibility.
And has Miss Kihembo been advised as to
Yes, yes, my lady, she has. But I also submit respectfully, my lady, that it is also possible to this court that if it finds that the approach is in some way problematic, but not entirely, such that nothing can be preserved, that is also possible. And I make the point, my lady, that there's been no challenge to that finding by the respondent. And there's no cross-appeal on that point. Those are the points, my lady. And I know, my lady, that the Upper Tribunal, for example, in this case, decided, as it was open to it, to keep some finding and to get rid of some finding. And in the same way, it is open to this court, if it so finds, to either keep findings or to remit entirely to NIVO.
All right.
Thank you. I'm grateful. My lady, on the point about relief and academicness, I mean, I can address you on those. Those are well set out in the two submissions that are in the core bundle.
Well, I think we've heard your appeal effectively,
Yes.
so I don't think we need
It's
to
a bit
go
late to
there.
say that.
Thank you.
But is there anything further, Mr. Faz?
No, my lady. And my lady, in terms of relief, I've said those out in my skeleton at length. I don't need to address you orally on those.
All right, thank you very
Very
much.
grateful.
Anything further? Thank you very much, Mr.
Thank
Faz.
you.
Miss Patrick, would you forgive us? We're finding it very cold
It is.
at the moment. So we're going to break, I think. And it may be, since it's 10 to 1, that subjects to everyone's convenience, we could perhaps come back at 10 to 2.
Absolutely. I was only going to set out the structure of what I was likely to say, but they can absolutely wait until 10 to 2, so that's fine. It is cold. I have my thermals underneath the gown.
Yes, some of us have, but others haven't. so that we can concentrate on what you're saying.
Absolutely.
So, 10 to 2, is that okay? Yeah, is that okay, Christopher, David? Yes, thank you very much. 10 to 2.